Hello and welcome to this Field Seymour Parks webinar on redundancies. My name is Ian Machray. I head up the employment law team here, and this is part one of a two-part session exploring sort of redundancies, particularly in the current pandemic that we face. So before we get started, a few sort of housekeeping points just to let you know. You're all currently on mute at the moment. It is nothing personal, just allows us to manage sort of the numbers of people on the session. But you will have the opportunity to ask questions. So you should see there's a sort of question box. If you type your questions in there, then I'll open that up at the end of the session and answer as many as I can. I've left time for that at the end. And equally, there'll be some polls as we sort of move along, an opportunity for you to sort of vote and give your views on things. So I'll flag those up when we come to them. If you want a copy of the slides, they should be able to download them from the handout section. And in any event, this is being recorded, and the recording should be sent to everyone this afternoon. And then I guess the only final thing I should say is that this obviously is being done remotely as we're in lockdown at the moment. So hopefully there won't be any issues with technology, children, dogs, guinea pigs, and we won't get interrupted today. But anything that goes wrong, my apologies, but we'll be doing the best that we can to keep it professional. So let's crack on and have a look at what we are talking about today. So let's have a look at what we're going to cover. So going to start off, I guess, with the most obvious thing. We're going to look at why does any of this matter? Obviously, the fact that you're on this call, on this webinar, suggests you understand there is some importance in getting these things right, but we'll have a look at why it's important, some of the consequences if you get it wrong. We'll also explore some of the alternatives to redundancy and this idea of sort of before and after, which I'll explain when we come to it, but really it's about having a clear vision as to what you're looking to achieve with your redundancy process. That lends us into choosing the right path, which is all about making sure you get your process and procedure right and picking the one that's appropriate for your circumstances, anticipating any problems that might arise. And as I'll explain, whilst the process does differ depending upon your circumstances, we'll look at the four key elements that every redundancy process needs to cover. Finally, we'll pick up on some of the common issues that can sort of arise and throw people whilst they're going through a process, and then we'll pick up with the final elements of termination and payments that are due. So before we proceed any further, I'm going to ask your views on something. So we're going to get a poll running. Let's get this up. So my question to you is, how many redundancies were recorded between July and September 2020? So was it 35,600, 128,650, 314,000, or the top one, 650,000 and 125. So this has been in the press a little bit recently, somewhat unsurprisingly, but I thought I'd see if you knew how many we've had in that sort of past 3-month period. Right, let's see what your views are. There we go. So 67% of you have gone for 314,000, and you are correct. Congratulations to you all. I'm afraid there is no prize for getting that right, but yeah, it was 314,000 over that 3-month period. It's the highest 3-month period of redundancies on record. I think the records go back to 2005 for that particular stat, so it's not forever, but it is a considerable period of time. And obviously there has been sort of the benefits of furlough during that time, which has obviously brought down those numbers from could have been probably significantly more. So obviously a serious problem at the current time, and a lot of organisations are talking about running redundancies going forward. So why does all of this matter? Why does it matter in terms of getting your process right? Well, the first thing to mention is something that will be covered in part 2 of this session, which will be recorded on Thursday this week, which is about collective consultation. And we'll talk about what that when that's triggered briefly, but in short, if you get that wrong, there's a tribunal claim there for each employee that's potentially worth up to 90 days pay, and there's even some criminal sanctions involved as well, not only for the employer but also some of the people in sort of management or executive roles. Then you run the risk of unfair dismissal claims. So for a normal unfair dismissal claim, you normally have to have 2 years service as an employee. But if you get your process wrong, then you could be facing having to pay out for a basic award, which is calculated similar to statutory redundancy payment, and also a compensatory award, which is all linked to loss of earnings. And there's a cap on that of a year's gross earnings, or just under £90,000, whichever is the less. And there's also the risk that the tribunal might order reinstatement, which is allowing the employee to get their job back, or re-engagement, which is returning to your employment but in a different role. There's also risks, automatic unfair dismissal claims, which don't require any length of service and are uncapped, which is where you dismiss or select someone for redundancy on protected grounds. Discrimination claims are again similar, because there's again no length of service requirement and uncapped awards, and we'll talk about those elements a little bit later on. Contract claims as well, need to make sure that there's sort of no breach of contract that's going to give rise to damages as well. So in short, there is a multitude of good reasons why you want to get it right legally. In reality, also, there's always very important business grounds why you want to get these things right as well, as I'm sure you'd appreciate. You don't want the reputational damage of a bodged process. You don't want to damage the relationships with your remaining members of staff. And frankly, you want to make sure you've got the right people in the business moving forward. So for a whole host of reasons, this is important stuff. So I'm going to ask you another question now, which is linked into this point of sort of possibility of increase in tribunal claims. So the question is, how many more tribunal claims, so what percentage did they increase by basically in April to June of this year in comparison to the same period the previous year? So from April to June 2019 to the same period in 2020, what was the increase? Was it no increase, 5% increase, 12% increase, or an 18% increase? So obviously this period was sort of at the start of the lockdown period, April to June. And let's get your answers up. There we go. So 69% of you think 18%, 15% each think of a 5%, 12%. None of you think it was 0. Which was is right. So the right answer is an 18% increase. So what I would say about that is in a period where the effects of COVID for a number of businesses would only just have been started to be felt. Employees normally will have at least 3 months to bring a claim. So I would anticipate actually when we get the statistics for later this year, they will have gone up again and potentially significantly so. And the sad fact is that the tribunal process is struggling under the strain, and cases are frankly taking longer and longer to get to trial. But we will get more stats on that soon, but I will be expecting that to go up again further. So let's get into the bulk of the session now, really, and starting off with, well, what are the alternatives to redundancy? And this is important for 2 reasons. One, legally, as we'll talk about when we come to process, you have to consider alternatives to redundancy before you make employees redundant. But also from a business perspective, redundancy processes can be time consuming, they can be demoralizing, and therefore if there are better alternatives, you should be considering them right at the outset, which is why we're dealing with this right at the start of this session. So most obvious current one, certainly for this year, is the possibility of furlough. As you'll have seen, the scheme has been extended now through to the end of March, although the level of government support will be assessed in January. But obviously that is a potential way to save costs without potentially making redundancies. Likewise, pay reductions or changes in benefits. That's something we've seen a lot more of this year than in well, as long as I can remember, really. But there is the possibility of agreeing with your employees pay reductions for a period of time, or maybe ceasing or changing employee benefits. Similarly, you could have a reduction in hours with a corresponding reduction in pay. You might want to check your employment contracts to see if you've got layoff or short-time working provisions in there, which might be helpful. If not, you could still potentially agree something with your employees as an alternative to redundancies. Some obvious things often to consider: stopping recruitment or reducing recruitment, reducing overtime, and are there other people providing services whose relationships should sort of be terminated before your employees? So self-employed contractors or consultants, use of agency workers. You might want to look at those first before you actually sort of start to reduce your number of actual employees. Retraining can be useful if there is the possibility of maybe one part of the business is doing better than another, and there's opportunities for someone to retrain and remain in employment. Unpaid sabbaticals, so people may be taking 3, 6, 9, 12 months from work without pay, can be an option in terms of cutting costs in the short term. And then voluntary redundancy or early retirement, you can also consider as well, and we'll talk about those in a little bit more detail later on. So if you've concluded that those alternatives aren't going to fix your problem, aren't appropriate in the circumstance you've got, one of the things I would really stress is this idea of having a clear vision of the before and after. So that probably conjures up images of some sort of horrendous diet with sort of the before and after shots of the individual. But what I'm talking about here is your business, your organization, understanding exactly what it looks like now and exactly what you envisage it look like after the process has been completed. And as you'll see, as we flow through this, getting that right and understanding that is crucial to the whole process you follow. So you need to understand what is changing and how it affects your business structure. So you might need to be looking at organizational charts. What does it look like now? What does it look like afterwards? Job descriptions or understanding of job specs, salaries in terms of employment, where people are working. Is there any location changes? Obviously, a lot more home working occurring at the moment. And then what are the skills, experience, and qualifications? So it's just being able to have that clear vision and being able to explain what the business looks like now and what it looks like afterwards. And for some organizations, that'll be quite straightforward in terms of the current situation, because they'll have very clear job descriptions, they'll have very clear org charts. If you don't, you need to go away and do your homework to make sure you properly understand what people are doing and what their roles are. The other thing I should say here is this shouldn't all sort of sit in the head of an executive. Whoever is running this process needs to understand that sort of vision as well. Okay. It flows naturally from that, in that if we're looking at what the before and after is, the question you have to always ask is, well, is it even a redundancy situation? And in very simple terms, there are 3 types of redundancy situation. Business closure, which is pretty much exactly what it says, which is where business ceases to trade. Place of work closure, which is where a location of work might be shutting down. And then where there is a reduced need, a reduced requirement for employees to carry out work of a particular kind. That's the one that's often more difficult to apply. But for example, could be a situation where you have 4 sales executives and for whatever reason you now only need 3, reduced sales work of some sort. Now, those are your sort of redundancy sort of definitions as those recognised in law, but the reality is the situations can vary very widely, and what you need to make sure is that you've chosen the right path when you set out on your redundancy process. And there are 4 sort of key elements that I'm gonna explore, I guess, in terms of sort of questions in terms of getting that process right. First one is whether there is a need for a formal collective consultation. I will touch on that briefly because that is the focus of the session that's coming up on Thursday, but it is relevant here when choosing your process. Then the distinctions between sort of unique roles and pools of employees. Complications that can come from more complicated redundancy situations where maybe there's a restructure or a change in terms. And then how does voluntary redundancy and or settlement agreements fit in with those processes. So those are the 4 things we're going to look at briefly, starting with collective consultation. In short, where an employer is proposing to make redundant 20 or more employees over a period of 90 days or less at a single establishment, then you will have a collective consultation obligation. If you need more detail in terms of when that is triggered or not, that will be part of the focus of the session on Thursday. What I would say is that if you think you are close to that, go away and make sure you are clear as to whether or not you have that obligation. If you do have that obligation, there is a formal process you have to go through, informing and consulting with appropriate representatives. You also need to notify the Secretary of State, and there's specific minimum time periods in which you need to do that. And again, as I talked about earlier on, this is an important one to get right because 90 days pay, potentially for each affected employee, and potential criminal offence as well. And there's no length of service requirement for those claims either. But moving on, as we're focusing on sort of individual consultations today, one of the other sort of key question employers face is basically which employees should be at risk of redundancy. And this is a sort of concept that employers often struggle with. And it's to do with trying to identify whether you have someone who is in a unique role. So there is one individual who carries out a specific function, and because of, for example, the reduction in work of a particular kind, it is only them that needs to be at risk of redundancy rather than a wider group or pool of employees. As opposed to my earlier rather basic example where you've got 4 sales executives, there's a reduction in work and you only need 3. There you clearly have people who would need to be placed in a pool for a scoring process. Now, identifying whether or not you need a pool is not always straightforward because there's a lot of factors that go into it. But your starting point should always be looking at the type of work that is ceasing or diminishing. So if you understand what is causing your redundancy process, why is there less work, what is the work that there is less of, it should hopefully automatically follow from that the people who are potentially then at risk of redundancy, because they will be those people who carry out those types of tasks. But you also need to look at the extent that employees are doing similar work. You should consider the locations they're performing that work at. It doesn't always follow that pools have to be limited to a geographical location, but it is a factor to take into account. And are jobs interchangeable? So could employees swap roles? Do they have the skills to sort of swap roles? And does that happen in practice? Again, something to consider. Obviously, to the greater extent that the roles are similar, the closer geographical location is, the fact that they're more interchangeable, all of those things will point towards you potentially having to have a pool rather than just singling out one individual as having a unique role or a pool of one, however you want to label it. If you do recognise a union or you've got employee representatives, maybe for a collective consultation process, that is something that you would normally need to seek their views on as well. One thing I would flag up on identifying your pool is this idea of bumping. So this is moving a potentially redundant employee into another employee's role and making that employee redundant instead. Now that is permissible and that can result in a fair dismissal, but it does require careful consideration. You don't have to do it, but it is, we would normally recommend something that you at least consider, even if it's something that ultimately you discount. It is most commonly used, I would say, probably where you have a sort of senior employee being made redundant and they are willing and able to step into a more junior employee's shoes, and the more junior employee then be made redundant. Obviously, getting this stage right is important legally because it links in very much with unfair dismissal claims. Have you applied your mind correctly to the issue? But also it has business significance as well, in that if you get your pool wrong, there's a risk that you end up with the wrong people in work at the end of this, and you lose key skills as a result of your redundancy process. So it is important to get it right. So third element to talk about in terms of choosing the right path, getting your process right, is about restructuring and changes in terms. So this is where you're facing a more complex situation. So it's not just a case of maintaining your current job titles, structures and roles and just maybe reducing the number of people in a certain sector. This is where you are creating new roles, and this has an impact on your process. And in short, the classic sort of pooling of employees and scoring of them may not be appropriate where you have a restructuring process where you are creating new roles. And a variety of reasons for that. One is it's quite possible that if you are creating new roles, that none of your current employees may be suitable for that role. So you could be pooling them and you could be scoring them, but actually the role you've created is something which requires a completely different skill set, different qualifications, and therefore just selecting who's the best of sort of your existing employees isn't going to be appropriate. You're not going to get the right skill set. You also have to consider that the employees may not even want the role. So if it's different responsibilities, different duties, different terms, then you can't automatically assume that they're going to want that new role that's created, and therefore sort of pooling them all together and saying, congratulations, you're not being made redundant and here's this role. Well, that doesn't work if they don't want it. So you need to think about your process. And what you may need to consider doing is sort of an objective sort of application process for those new roles. And as we'll come on to, you'll still need to ensure that there's objective and it's evidence-based and everything else. But don't feel a slave to sort of the pooling and scoring route, because it is not appropriate in all circumstances. The other thing I would flag up in here is sort of a change in terms. And it is possible that if you are just looking to change an employee's terms of employment, that it may not be a redundancy process at all. So if, for example, you were looking for them to take a salary cut or to work some additional hours or change their benefits, that's not necessarily a redundancy situation. You have to go back to those 3 definitions we looked at earlier on. Now, that not to say that you can't do it necessarily. You can bring out changes in terms through a formal process, but it's a different focus and a different process is required. So again, just be careful that if you have got something which you think might be properly classified as a change in terms, that you get advice and you don't go down a redundancy process where actually something else is required. So the final element of choosing the right path I wanted to talk about is the idea of voluntary redundancy. And a question that often comes up is, well, when is the best time to propose voluntary redundancy? And it very much depends upon your circumstances and goes back to the situation that you're currently in that if, for example, you just need to broadly cut costs across your organization, or you have a number of people doing a very similar role, then you could say, well, actually, there is benefit in starting a voluntary redundancy process and putting that offer out there very early on, before perhaps you have even sort of considered what your compulsory process might look like. Because frankly, you just need to cut some costs, you need to cut them quickly, and putting that offer out early on might be the best option. The flip side to that is where actually you just need to be careful that your voluntary redundancy process is not going to cut skills, qualifications, experience, whatever it might be that you still need. And a very broad approach to voluntary redundancy could cause you to lose the wrong people. And that would suggest that actually the better time to be doing it would be maybe slightly on in the process once you've got a more concrete vision, a more concrete proposal as to where the redundancies need to fall, and then limiting those offers of voluntary redundancy to more limited groups of employees. So no hard or fast answer on that. And it's a similar thing with the enhancement. You don't have to enhance voluntary redundancy at all. You can just put out an offer of voluntary redundancy that will be paid out on a statutory basis. If you do choose to enhance it, then you just really need to balance, I guess. There's obviously the sort of the social or moral factors in terms of, well, do you want to try and look after people after being made redundant? But the business side of it is, well, what do I gain through voluntary redundancy? Well, you will gain, if you get enough and you get the right people, you'll gain avoiding a compulsory process. And you may be able to sort of put a figure on that, saving time, maybe even saving legal fees in terms of getting advice on that process. And that may then feed into what you're willing to offer to encourage people to take voluntary redundancy. What I would say is it is normally wise to reserve the right on voluntary redundancy to turn down any applications for it, because it may not fit with the skill sets that you're looking to lose. But you do need to just be a little bit careful that you are have considered and have got good grounds for turning down such offers. Finally, do I need a settlement agreement? Well, if you are enhancing the payments that are received by the employee, we would normally recommend that you therefore get them to sign a settlement agreement so you get that full and final waiver of claims. If you're not enhancing, or you're enhancing very small amount and you think that is low risk, you don't have to have a settlement agreement, and you may just have sort of a countersigned letter or something of that nature in which they acknowledge the payment and that they have volunteered for redundancy and have no sort of concerns or issues. It won't give you the full and final settlement, but will give you some comfort and may be appropriate where there's no enhancement or the enhancement is quite small. So that moves us on to sort of the next topic that I wanted to talk about, which is anticipating problems. So I hinted at this earlier on when we talked about why it's important in getting the process right. But you just need to be aware that if you dismiss someone, you make someone redundant, or you select them for redundancy, and it is on any of the sort of protected grounds that can lead to automatically unfair dismissal, and then you can obviously face a claim as a result, and there's no length of service requirement. So if you are selected someone because they have recently been on family leave, they have put in a flexible working request, they have part-time or fixed-term status, then you'll end up facing a claim. And I suspect for the majority of employers, they're not going to be selecting anyone on those grounds, because that's not something that they would seek to do. But you still need to be aware that if you have an employee that falls within those sort of potential categories, then you're just going to need to make sure that you've got your clear justification for what you're doing, so that if they do make those arguments, you're in a position to rebut them. Also be aware of discrimination claims and someone alleging that you have made them redundant or selected them for redundancy on protected grounds, and in particular be aware of indirect discrimination, the most common form of which in a redundancy process often arises from taking into account length of service. So in very simple terms, if someone has 20 years of service, it is likely they are to be older. If you favour them in the redundancy process as a result, you could run the risk of indirect discrimination claims for younger employees. So you do need to be careful on length of service requirements. If you do choose to use them, then use them in a package with other sort of selection terms, and also make sure you limit the number of years of service you're taking into account. Two other things briefly. Check that you don't have any contractual obligations. So do you have a contractual redundancy policy? If so, you're going to need to follow the terms of it, or else you're going to face a breach of contract claim. And just remember that certain employees on family-friendly leave, maternity, adoption, shared parental leave, will get priority for suitable alternative employment. So if you have someone who falls into those camps and they're facing redundancy, you need to be aware that they may get priority for alternative jobs that are available. So you've chosen your correct path, you've anticipated your problems. now I want to talk about your process. And as I say, this varies depending upon your circumstances, but there are 4 key principles that will apply to pretty much every redundancy process you follow, which is early warning, genuine consultation, fair selection, and considering alternatives. As I say, this is a flexible process. There are no set time limits for individual consultation, but on the basis I'm talking about early warning and genuine consultation, those are the things that will govern how long you need to take. So early warning, this is linked to the obligation to consult. So you need to be telling people that something is brewing, something is looming in terms of redundancies early enough so it can make a decision and you can have that genuine consultation. You need to be clear that your plans are provisional and not final decisions. And equally, it links in again with the third point I'm going to talk about, which is alternatives to redundancy. There is a risk, particularly with people on maternity leave, we see, where employers think they're on maternity leave, we can't have discussions with them about a redundancy situation. And so they delay until the person comes back to work. The problem with that is that you won't have given them early warning. And in failing to give them early warning, there may have been alternatives to redundancy that have arisen in that interim period that are now closed off. So jobs that vacancies that might have arisen, well, they're all now filled. So you need to be careful and make sure you give that early warning. And what I would say is what we often talk about is the concept of sort of bookending your process. And by that, what I mean is ensuring that you are documenting, in particular at the start and at the end of your process, your rationale. So at this stage, you need to be clear about the risks that the organisation is facing, the jobs that are at risk of redundancy, the reason for it, and the alternatives that are being considered. You may also be looking for volunteers at this point. But what you want to do is make sure you've got a comprehensive document of that, normally in letter form to the employee, and you do that at the start and you do it at the end. So that if anyone ever looks at the documents or is questioning the process, you've got some very clear rationale so that you're always in a position of strength. Genuine consultation. So this needs to cover your pool or lack of and the selection criteria you've chosen. The application of that criteria, so the actual scores or assessment related to that employee. Alternatives to redundancy, so the employee may have suggestions of their own there. Alternative employment that might be available, which we'll talk about a little bit more in a moment, and any other concerns that the employee may have. Now, there's often a lot of discussion about, do you need to explain or do you need to consult about your business rationale underlying the redundancy situation. And what I would say is that in reality, for there to be a genuine consultation and for the employee to understand the situation they're facing, you will probably need to disclose an element of your business rationale. That doesn't mean necessarily absolutely everything and all your forecasts and everything else, but it's quite difficult, and indeed you run the risk of the employees questioning the process more if you are not clear at the outset why you are having to do what you are doing. You need to show you've got an open mind and you've considered whatever the employee has to say. It doesn't mean you have to have agreed with it, but you do need to show that you've considered it and taken it into account. And obviously, with the current restrictions we have due to the pandemic, and doing these things remotely by video call, by telephone call is absolutely fine. Third element of any process is fair selection. As I said earlier on, how you do this will differ slightly on your process. Is it a restructuring? Is it a pooling process? Is it a unique role? But what should be the driver of this is the needs of the role and the needs of the business going forward. So if you're selecting, you should really be selecting with having that in mind. What does the business need? And the other thing I'd say is be specific. So you'll often hear people saying, oh, well, you can score people on disciplinary, you can score them on performance, you can score them on qualifications. Yes, you can, but you should be a lot more specific than that. So what elements of performance are important to the role? What qualifications are specifically needed? What skills are required? The more specific you are, the easier you will find the second element of this, which is about it being objective. And there are two ways that you can help your assessment be objective. One is to have it backed up by evidence, so you might have documents, performance reviews, etc. That would all be relevant. Or two is to involve more than one person in the process in assessing the capabilities or the scores of that employee. But try to be as specific as possible. Try to avoid things that are very subjective in nature, i.e. something that is just one person's opinion. And always be clear, linking back into the consultation, those scores are provisional and subject to consultation, so they may well change as part of your genuine consultation and having an open mind. I mentioned furlough briefly because this is a question that comes up. Can I automatically select people on furlough for redundancy? The short answer is no. You're going to need, despite the fact that you may have placed them on furlough, you still need to go through this fair selection process, and you can't automatically assume just because they're on furlough that they're the ones redundant rather than those who've maybe still remained working. Fourth key element of any process is considering alternatives. So we talked about this at the outset. So all of those things you should already have considered, and indeed you can consider again as part of your consultation. So the focus I've got for you here is about alternative employment. So you should be considering options for alternative employment. You should in some way document that search, even if it's just to indicate that you've looked and there's nothing. Consider any wider corporate group if you've got one, because those any open positions there should be considered. And you also need to continue your search until employment actually fully comes to an end. Where employers often fall down is they will give an employee notice of redundancy. They will have, say, a 3-month notice period. Maybe they're on garden leave for that period, and they stop looking for alternative employment, despite the fact that the employee will still be employed until that notice period expires. So you need to keep that search up, despite the fact that you may have already concluded and given notice to the employee. Other thing to flag is you need to give the employee sufficient information so they can properly consider whether or not the vacancy is suitable. So not just necessarily job title, salary, terms, benefits, specifications of the job, responsibilities. They're going to need to know some details of it. Consider how that application process will fit in with the timings of your process. Obviously, if people are applying for alternative jobs and there is a process that needs to be considered there, that may impact upon the length of your redundancy process. And one thing I would say in respect to this sort of alternative employment, this is about looking for vacancies, jobs that exist or jobs that are going to be created as part of this process. It doesn't require you to create something specifically for the employee. It's about notifying them and giving the opportunity to be considered for vacancies that already exist. In limited circumstances, I should add that if an employee unreasonably refuses an offer of suitable alternative employment, they can lose their right to a statutory redundancy payment. Only things I would say there is that it's relatively rare that comes up in practice, because it's quite a difficult threshold to get over before they lose their statutory redundancy payment. And the other thing I would say is don't get that concept of losing the statutory redundancy process mixed up with this considering alternatives. What you should be doing here is notifying the employee of any vacancies. You don't need to be carrying out an assessment of whether or not they're suitable. Notify them of everything would be my advice. Obviously, you can then determine in due course if they apply for it whether or not it is suitable, but this is about notifying them of anything that might be available. There is a statutory trial period of 4 weeks if an employee starts a new job as an alternative to redundancy, so be aware of that as well. So, dealing with unforeseen issues. Let's try and stop them from being unforeseen, I guess, as much as we can. But this does come up. So you'll be midway through consultation, and there will be some change in the factual circumstances. So maybe an employee will resign from the group that was at risk of redundancy. Maybe you will secure a lovely new client contract that guarantees more work, or maybe there'll be some unexpected alternative to redundancy that crops up, like an employee all of a sudden saying, I'm quite happy to go on sabbatical for a year unpaid, or something of that nature. What I would say with those things is the key is that you need to keep your redundancy decision under review until such time as the employee actually leaves your employment. So if something does occur, you're going to need to consider it, you're going to need to review it, and then you're going to need to document in some way what your decision is. How has it impacted on the process? And it could well be that despite these changes, there is still a need to proceed with the redundancy process as planned, but just document that you've considered it and why you're proceeding as before. You know, for example, you may have won a lovely new contract, but it's not actually going to generate any more work for the employees who are at risk. Common problem in particular this year has been change in legal position, particularly on furlough. We've obviously had a lot of extensions at sort of last minute, some changes to the level of financial support available as well, scope of the scheme, all these things. And again, there's not much you can do about that apart from, again, keeping it under review, listening to what the employee has to say, and adjusting your process if necessary. Hopefully we have at least an element of certainty that the furlough piece will now continue to the end of March. Two other things I'll briefly touch upon that often come up: illness and absence from work. So you start your redundancy process, employee suddenly disappears off on sick leave. And what I would say is that doesn't necessarily mean that you just have to stop or cannot proceed with your redundancy process. You may well need to consider adapting it. Can you consult with them remotely? You might be doing that anyway to begin with. Can you do it in a way that takes into account whatever their illness is? You may need to delay it slightly if it's a short-term absence, but ultimately you may not be able to just stop the process there and then. For example, if you have a process that involves other employees, you have an obligation to consult with them and to give them certainty. So you can't just leave it open-ended forever. So you need to consider it, you need to adjust, but when push comes to shove, you may well need to continue with the process as best you can. Grievances often come up. Employees placed at risk of redundancy or told they're provisionally selected, and then they pop in a grievance. How to handle that depends upon the nature of the grievance. So if someone is making a complaint about the redundancy process, you may be able to say, well, actually, it's appropriate for us to consider this as part of the normal redundancy consultation. If, however, it's slightly more fundamental, maybe, for example, making a serious allegation against the manager who has done the scoring process, then you may have to say, well, actually, we can't complete the redundancy process until such time as we've resolved the grievance. But don't automatically assume that, because that won't always be the case, and you could sort of derail your process and cause problems elsewhere, particularly if you have other employees that are at risk and want to know what's going on. So let's assume worst case scenario, you've gone through all these steps and you're reaching the point of termination. I'd go back again to this process of bookending your process. So ensure that in the same way you've ensured your first letter to the employee is comprehensive, ensure that your last letter to the employee is comprehensive as well. So I would repeat everything that you've had from your first letter in there, so your business rationale, what the situation is, why it impacts upon them, but also then detail the process you've gone through, the meetings you've held, the dates you've held them, the points that have been raised, the response to those points, any changes that you've made as a result of that consultation. If you haven't made any changes, maybe explain why. If there's been alternatives to employment discussed and rejected, then record that as well. And obviously you can now finalize the payments that are due. But I think if people say about presentations, I think, don't they? You should tell people what you're going to do it, and then tell them what you've done. I don't know if that makes for a good presentation or not, but it does. It is a useful tip in terms of ensuring your redundancy process is properly documented. You've got two golden opportunities at the start and the end of the process of ensuring that your rationale and reason is properly documented, which will be invaluable if the employee is seeking to challenge it or taking legal advice or going off to a tribunal or court. We'd normally recommend you consider giving a right of appeal. You don't have to do it, but it is a very useful way of flushing out any issues and potentially resolving any issues with the process. So we'd normally recommend that. Right, I've got one final question for you. Let's get that up for you. So, topical. Can you claim a furlough grant for an employee who is under notice of redundancy? Only three options today: yes, no, and the lawyer's favourite, maybe. So this is something that has been receiving some publicity recently. And the position has, only in the last few days really, or maybe it was yesterday, has been clarified. So let's see what you think. Share those results with you. So good split on this one. So 53% say yes, 27% no, and the 20% are hedging their bets with a maybe. And the short answer is I would have sympathy for all of those answers. We can say you all got it right. Everyone's a winner, because the situation is changing. Okay, so we're going to have a look now at payments. And let's deal with that furlough point first, and we'll come back to statutory redundancy payments. But what we've seen over the last few months in particular is employers have been using, and it has been permissible to use, furlough grants to help fund notice pay. So where an employee is serving out their notice but not required to work and kept on furlough, employers have been keeping them on furlough and claiming the money for the government for that period. Few caveats on that. Obviously, all the normal requirements of the furlough scheme have applied, and it needs to generally be topped up to 100% of pay. So the employee should not be disadvantaged as a result of doing that. So that has been happening over the last few months. But what the government has said with this latest extension of the furlough scheme now until the end of March is that from the 1st of December, it appears that that will no longer be permissible. So you will end up having to fund notice payments in full. So whilst, and if you have a notice period that overlaps, so it's part November, part December, then you'd be able to claim it for the bit that falls into November, but not the part that falls into December or any period thereafter. It was something that was hinted at when the sort of the aborted job support scheme was brought up. But yeah, that's the position going forward. So in terms of other payments, statutory redundancy payment, I'm not going to talk about that for very long because I want to have a look to see if I've got any questions you want me to answer. But you do need 2 years service for that. You can find the government calculator online, but it's basically age, length of service, and weekly wage. Weekly wage is subject to a cap, which changes each April. And that gives you statutory redundancy payments due to the employee. Check you don't have any contractual obligations to give a redundancy payment, so you might have a contractual enhanced redundancy scheme in writing somewhere, in contract, in a policy. Also be a little bit careful where you've had a custom and practice of paying enhanced redundancy payments and you are looking to change that custom and practice, so looking to move away from it in a way that is less favourable. Just be careful, maybe take a little bit of advice before you do that, just to be careful that the policy hasn't become contractual over the course of time through a consistent custom and practice. Notice pay, it's the same as always really. 3 main options with notice. The employee could work it out. You could ask them to carry on working, although that's pretty rare because you've just told them they're redundant, so in theory you don't need them. And also often not the most motivated employees ever. but it's possible, particularly for periods of handover and things like that. The other alternative is they could remain employed throughout their notice period but not work, and that could either be sort of on garden leave or for a short period of time you've got the possibility of using furlough. And then you can do a payment in lieu of notice, which is where you terminate their employment with immediate effect, and you give them a lump sum in lieu of the money they would have earned during their notice period. That's quite common, but please do check your employment contract and ensure that you've got a payment in lieu of notice clause in there. If you haven't, then by making a payment in lieu of notice, you'll be in breach of contract, and it might invalidate any sort of post-termination restrictions you've got in the contract. So it is something that a lot of employers do, but please just check it's permitted in the contract. Accrued but untaken holiday pay is normally paid out on termination as well. And just check there are no other contractual sums as well, so commission payments, things of that nature. Right, well that leaves us on to questions. I'll open up the questions box and see what we've got in there. Before I do that, I'll just flag up the collective consultation webinar that we have on Thursday this week. That will be talking about those slightly larger scale redundancies. And then my colleague Louise Smith will be taking a much nicer subject of retaining employees, which is next week. So a week today, I get the subjects, which is all about getting rid of people. She gets the nice stuff about how to retain people, but still a key question in the current climate. So if you bear with me one moment, let's just open up the question box. So few here. So the first question I've got, and by all means add any in now, and I'll do my best to answer them. But the first question I've got is one about bumping. So in the case of bumping, is it not possible that that could give rise to age discrimination claims because you favoured a senior employee over a junior employee? You're right, there is a risk, and there's always a risk with a bumping dismissal anyway. The reality is that you would need to make sure that if you were bumping, so let's take the obvious example, you've got a senior manager and that role is redundant, but there's a more junior role that they're capable of filling below them and they're willing to do it. If you were looking to make that more junior employee redundant and the senior employee slot into their role, you would need to do an objective scoring process. So you'd need to establish that actually that senior employee, you shouldn't just assume that the senior employee is better. You'd need to demonstrate that they are better and have better skills, qualifications, whatever it might be, than the junior employee. So you'd need to do your sort of pooling process of the two, and then you would need to be able to justify. And obviously if you've got fair objective grounds that are nothing to do with age, then you should be fine. But you're right, you do need to be a bit careful about it. And bumping dismissals can be contentious because the junior employee will normally turn around and say, well, why am I being made redundant? Because it's not my role that you're getting rid of. So there it is one to be careful with. Other question I've got here is, sort of the advantages and disadvantages of redundancy versus pay cut. So I guess any of the other alternatives to redundancy that I flagged up. Well, I think this goes back to your business rationale. What are you looking to do as a result of the process? If, for example, you've got a short-term dip in work and you're anticipating things will pick up in due course, and as and when they pick up, it's going to be very difficult to recruit again, you might be thinking, well, maybe trying to agree a pay cut with employees will be a better option. If, however, you've got something that is more structural, and you're anticipating that actually there's going to be a long period of time, then pay cut may not be quite so appropriate. You may end up demotivating all your staff. You may end up losing the better ones. So there's no right or wrong answer. From a legal perspective, you just need to consider the implications of what you're doing, basically. Another question here, clarifying the objective scoring process in a bumping situation. Well, it would probably be assuming it's a role that's already in existence, you'd probably do it through a sort of a classical scoring process. So you would pool the more senior employee and the junior employee, or it might be a wider group than that, might be more than one junior employee, and you would then need to determine what your criteria are going to be. So it could be certain levels of performance, certain skills, certain qualifications, disciplinary records, and then you'd need to score them in a similar way that you would do if you had a number of sort of junior employees in a pool and was scoring them as well. Another question, do we have to offer voluntary redundancy? No is the short answer. You don't have to, but it is something that would go to the fairness of any dismissal. You'd need to explain why you're not offering it, and there could be very good grounds as to why not, i.e. there are particular skills and experiences that you need to retain, and therefore offering voluntary redundancy out is not appropriate. And as I said earlier, if you do offer it, you don't have to enhance it, and you can sometimes you can obviously reject applications for it as well. Right, I'll do one more, I think. If there are any others, then please do sort of email me afterwards. The final one is, what's the best time for a settlement offer? So I'm assuming that's sort of with a view to sort of voluntary redundancy, I suspect. So it's similar to sort of the voluntary redundancy point I made earlier on. Timing of it really depends, in that what I would normally suggest with any settlement is you've got a clear vision you can explain to the employee or employees in terms of what's going to happen if a settlement is not done. And that applies whether it's redundancy, whether it's performance, whether it's misconduct, whatever your grounds are for making settlement. It is useful to know what your plan B is. And obviously you need to be carefully communicating with your employee that you're not suggesting there's some sort of fait accompli. But if you are looking for an employee to accept a settlement offer, they are more likely to accept it if they understand what will happen as a result. So the redundancy process is going to follow, what the rationale is, what the cuts and changes are that are likely to happen. I would normally be suggesting that you could make that offer at the same time as potentially placing people at risk, because you'd have given them all of that information. That might be a good time to make that type of offer to them. Remind you again just of the sessions we've got coming up. You'll get the links to sign up for those later this afternoon, I believe. I'll close the session shortly, but if you are able to just hold on and leave some feedback on the event today, that would be really helpful, and then we can try and make sure that we get our events as helpful as possible for you in future. But thank you very much all for attending, and I hope you all have a lovely day.